During the next session, we'll look at modern day slavery, labour laws, due diligence, labour disputes, and how each of these subjects intertwine with the UN Guiding Principles. I'm going to ask first Matthew Coghlan from Walk Free Australia to speak first, as he's going to set the scene for us and discuss the Murky Waters report that was produced by their organisation. So Matt, over to you, and then we'll come back to the other panelists for some quite good discussion. Thank you, Matt.
Okay, thanks very much. So thanks very much to Robert and others for the invitation to present. It's really great to be here, and hello to everyone who is attending this session. I'm Matthew Coghlan. I'm the Financial Sector Engagement Manager with Walk Free. I'm based in Melbourne, Australia, and my role concentrates mainly on the relationship between the financial sector and modern slavery. However, this morning I'm here to present a report which we launched last year on modern slavery in the Pacific, called Murky Waters. And many of you may be familiar with this report. I'm just going to give a top line perspective of it. And if we have any questions to ask or discussions to engage in afterwards, I'm very happy to participate in that. So the idea of Murky Waters was to bring together outstanding research on modern slavery in the Pacific. Up until this report, we had a fragmented range of research looking at different types of modern slavery in different countries. The most recent Global Slavery Index of 2016 had provided modern slavery estimates for Australia and New Zealand, but was very limited in its modern slavery estimates for Pacific countries. If I recall correctly, it only provided an estimate for PNG. So the methodology very quickly for the report was to look at existing peer-reviewed and grey literature, to look at work that Walk Free had done on assessing government action to address modern slavery, and then to conduct a series of semi-structured interviews in many of the countries in the region. Despite this, one of the key findings of the report is that there's significant gaps in knowledge still. And this is something I think we need to think about filling in the future. And just as a side comment, I noticed that in the most recent US Trafficking in Persons report, there's evidence that a number of Pacific countries are linking up with international organizations to do more research, which is a very positive sign. And then finally, as part of my introduction, just to note that the next Global Slavery Index will be published in the middle of next year. And we plan to do launches, promotion, education, and other events around that. And would really love your involvement in listening to and discussing the results of that next Global Slavery Index. Just a quick definition for modern slavery, because it's not always a term that's familiar to people. Modern slavery is an umbrella term which has come into vogue in the last few years, which describes different forms of exploitation and uses and captures different legal concepts. So those different legal concepts can be seen in the diagram there, such as forced labor, human trafficking, and slavery and slavery-like practices. And this Venn diagram is useful because it also illustrates the overlaps that might take place between those three key forms of modern slavery. For example, the relationship between forced labor and human trafficking can involve labor trafficking. The common thread running through all of these forms of modern slavery is that people can't refuse to work or can't refuse to leave their place, their situation, because of threats, violence, coercion, deception, abuse of power. In the Pacific, perhaps human trafficking is a more recognizable term, but as you can see from the diagram, human trafficking is just one form of modern slavery that we are referring to in this context. So what did we find out from the Murky Waters report? I guess the top line finding is in all 8 of the focus countries where the semi-structured interviews took place, we found at least one, if not more, forms of modern slavery. And those forms specifically were forced labour for forced labour exploitation or sexual exploitation, worse forms of child labour, and forced and early marriage. In this presentation, I'm going to focus on forced labour in particular because it's most relevant to my area of work. The report also revealed that modern slavery is taking place in well-known at-risk sectors, and this is the case in other regions, not just the Pacific. And you're probably very familiar with this as well. So fishing, logging, hospitality, tourism, construction, agriculture, horticulture, and also domestic work. And then the most affected people, the most vulnerable people, are also well-known at-risk populations. So women and girls and migrant workers. Migrant workers are particularly prominent in the case of forced labour. So why does this happen in the case of the Pacific? Again, there are strong parallels to why vulnerability occurs with other parts of the world, but obviously some drivers have greater emphasis in the Pacific than in other regions. So migration is a key feature of modern slavery in the Pacific, both inwards and outwards migration. In terms of outwards migration, that's often driven by poverty, which is related to demographics, as well as unemployment and lack of job opportunities. Natural disasters and increasingly climate change are forcing people in the region to look further afield for work. But also inwards migration. So as you would know, there's increasing foreign investment in Fiji and other countries in the region. And with that foreign investment, we're starting to see an uptick in indicators of modern slavery, if not actual cases of modern slavery. Discrimination of women and children plays a major role where women and children are involved through patriarchal norms, acceptance of gender-based violence, abuse of particular regional cultural practices, as well as issues relating to access to land in the case of forced displacement through natural disasters or climate change impacts. As you probably know, the region also experiences weak governance. And in the case of modern slavery, that tends to play out most particularly in limited labour inspections and weak law enforcement, particularly related to the criminal justice process and immigration border controls. And then in some countries, particularly the PNG and the Solomons, it seems evident that public sector corruption and complicity are a major factor in taking advantage of vulnerabilities to enslave people, particularly in relation to entry to the country, as well as industries such as fisheries and logging. And then finally, while it hasn't really been looked at closely, COVID might have had an impact in increasing vulnerability. For example, in the case of Pacific workers working in Australia under the seasonal workers program, many, if not most, weren't able to leave the country, but at the same time, the Australian government wasn't necessarily providing them with any support. So that will have increased their vulnerability to poor working conditions, as well as potentially modern slavery. So as I mentioned, I'll take a quick focused look at forced labour in the Pacific. It's increasingly being uncovered. Cases have been alleged or found in many of the countries of the region. As I mentioned earlier, some of the drivers of vulnerability relate to well-known at-risk sectors, the nature of the work being low-skilled, and the nature of the workforce involving a high proportion of migrant workers. The increased vulnerability for both migrant workers entering and leaving the region is created by disconnection from social and formal support networks, their low visibility and lack of transparency once they enter their destination country, their limited understanding of local contexts and any language barriers, in addition to the key sorts of elements that might be involved in labour migration processes that work to the detriment of labour migrants, such as the payment of recruitment fees by the labour migrants, contract substitution on arrival, and so on. As I mentioned, the migrant workers are centred in both foreign investment projects, which are increasing in the region, and what we're starting to see is foreign workers implementing some or all of these projects, many from China, but also from other parts of Asia. And then in the case of labour mobility schemes in Australia and New Zealand, where Pacific Island workers are working in particularly Australian and New Zealand agriculture and horticulture industries. Two good examples recently, which illustrate both the inwards and outwards migration involving forced labour, were the case of Samoans who were forced to work in New Zealand's horticultural sector. The trafficker and exploiter in that case was a Samoan national. He was found and charged with slavery and trafficking, and his methods were to confiscate passports, deny wages, subject his victims to verbal and physical abuse, and to control their movements. In another case, also from 2018, so very recent, over 100 Bangladeshis were trafficked to Vanuatu, by a fellow Bangladeshi. And they were forced to work in small properties and live in crowded spaces. Again, the use of violence and threats of violence was prominent in that case. So Murky Waters also looked at government responses to modern slavery in the region and found that there were significant gaps and weaknesses. And I've listed these here and I'll run through them quickly. So in general, there's low awareness of modern slavery amongst most stakeholders, from the general public and civil society through to first responders and law enforcement. There's a lack of reporting mechanisms and monitoring of modern slavery, especially for migrant workers working in remote locations. For example, the seasonal workers programs in Australia. There's gaps in the criminal justice frameworks. Some countries haven't ratified key international instruments, such as the Palermo Protocol, and others haven't criminalised trafficking or forced labour in their domestic legal systems. And then there's weak national and regional cooperation and coordination. So only some countries have national action plans and national coordinating bodies. And then there's fairly limited regional coordination. Perhaps the Bali process, which involves, I think, 11 Pacific countries, is the most prominent regional forum at the moment. And then related to vulnerabilities and drivers, there's a lack of social protection and social safety nets in Pacific Island countries, which mean that people are pushed to consider employment opportunities they may not necessarily consider. The US TIP report backs up these findings. Most recent US TIP report backs up these findings. So Fiji, Solomons and Vanuatu are listed as tier 2, and then Palau, PNG and Tonga are on the tier 2 watch list. There's been some movement upwards and downwards, but not a lot. Despite this, and on a positive note, I think there's been some really good developments in some of the countries in the region, and I think the Solomon Islands is worth highlighting for its efforts in the last 12 months. So it's continued drafting its National Action Plan on trafficking and smuggling. It's allocated budget to review and update its trafficking legislation and also accede to the Palermo Protocol and related instruments. Its anti-trafficking committee has met on a regular basis. It's joined up with an international organisation to conduct trafficking research in the fishing industry. And then it's also tasked an interagency committee to work with the business community in relation to labour laws, and most importantly, also funded that committee to do that work. Just in closing, I thought I'd share some developments in Pacific Neighbours, Australia and New Zealand. So as you probably know, Australia has had a Modern Slavery Act in operation since 2019. We've had the first round of reporting, and we've now started the second round of reporting. There's been a number of reviews of the quality of those statements. And in general, I think the findings have been that the quality is average, but improving. But having said that, there are some very good examples, particularly amongst big retailers, of risk assessment, due diligence, effectiveness frameworks, and remediation. So if you're interested, it's worthwhile having a look at the progress that Australian reporting entities are making to increase transparency in their supply chains. Next year, the Australian Modern Slavery Act will be reviewed. That's mandated by the legislation. And I think it's already clear what some of the key asks will be. And they might have, an impact on the oversight of Australia's seasonal worker program in particular. For instance, if the monetary threshold is reduced to $50 million, then that might mean smaller companies, which might do more business in the Pacific, will have to report as well. So other suggestions that have been made include introducing penalties. At the moment, there's only a name and shame provision in the Act, and there are no financial penalties. So many are arguing that that will help to increase compliance. It's long been advocated that an independent anti-slavery commissioner should be part of the Act. New South Wales has finally passed its version of the Modern Slavery Act, and it will include an independent anti-slavery commissioner. So the pressure is increasing, I think, on the Commonwealth government to consider that seriously as well. There's also discussion about the government setting up a modern slavery hotline, if it's interested in following up on that, which would provide a neutral, independent remediation mechanism. And then for those who follow this area in Australia closely, there's been discussions about different legal areas that impact on controlling modern slavery risks, such as forced labour import ban and the Magnitsky human rights sanctions. And then lastly, for me, in relation to New Zealand, Prime Minister Ardern has indicated that the government is working towards a modern slavery law. So that's something I hope to see in the near future. And an advisory group has been set up by the relevant ministry to help support developing that new legislation. So thanks very much. I hope this has provided a good overview for our discussion following.
Thank you, Matthew. And I think that's provided a real good example of what we're actually seeing in the Pacific and what kind of challenges and opportunities there are in different sectors throughout the Pacific. It's amazing to me the similarities in previous work I've done myself in Southeast Asia, or I remember going on the working group mission with Surya, who's actually in the room right now. And when we looked at like trafficking and the same sort of issues in Thailand in the fishing sector there, and so just the intersectionality of sort of the discrimination that people who are often subject to the human rights abuses face. So it's often migrant workers, it's often women, it's often children who are exploited, and many people who have not had access to healthcare or education that wind up in those kind of situations. So all these different kind of intersectionality of the discrimination faced. And I think it's really interesting that you pointed out the New Zealand government looking towards producing their own modern day slavery. Because I remember seeing in the press only a few months ago that businesses were actually calling for the government to produce this law as well. So I mean, again, talking in the context of business and human rights, it's really good to see kind of positive change that business can do to actually put pressure on governments to implement these kind of laws. And so this kind of brings us on to our second speaker, Ingrid Landau. And Ingrid is actually from Monash Business School, a lecturer in the Department of Law and Taxation. And Ingrid's going to really talk to us about how companies can look at human rights due diligence and how this works towards labour regulation. And I think that brings us into the larger conversation about social dialogues and how labour laws connect with these kind of issues that we see in the Pacific. So Ingrid, over to you, please.
Great, thanks, Robert. Good morning, everyone. I'm joining you from Melbourne, Australia. So I'd like to start by acknowledging the traditional owners of the land of which I'm speaking today, the Wurundjeri Woi-wurrung and Bunurong people of the Coghlan Nation, and pay my respects to their elders, past, present, and emerging. So I'm really pleased to be invited to speak today. And what I thought I could usefully comment on in the brief time is some of the connections between human rights due diligence and labour rights, and to talk about some of the challenges that I see emerging in this area. As we all know, the UNGPs outline the expectation that businesses will respect human rights throughout their operations and supply chains, and that they will implement this respect by having human rights policies, by having a human rights due diligence process, and by participating in remediation of any harms caused. And labour rights are kind of central to business responsibility to respect human rights. As set out in the UN Guiding Principles, the corporate responsibility to respect human rights includes respecting all those internationally recognised human rights. At a minimum, those are the rights in the International Bill of Human Rights and the ILO's Declaration on Fundamental Principles and Rights at Work. What this means, of course, is that businesses have a responsibility to respect rights to non-discrimination, to freedom of association and collective bargaining, to freedom from child labour and forced labour. And the instruments include other labour rights as well, such as the right to just and favourable conditions of work. The corporate responsibility to respect human rights and human rights due diligence is also appealing, I guess, from a labour rights perspective, because the UNGPs make clear that the corporate responsibility to respect workers' rights goes far beyond just respecting the rights of those that are directly employed by the business. It extends to respecting the rights of those in the business's supply chains, and it also extends to respecting the rights of those that work in the supply chain, whether they're in the formal economy or the informal economy. And obviously this is very relevant for regions like the Pacific, where a large number of workers are working informally. Also particularly relevantly for the region is that the responsibility to respect workers' human rights exists irrespective of the adequacy of national legal frameworks. So this is important, obviously, in regions like the Pacific, where labour law protections may be limited in scope, they may be limited on paper, but obviously they may also be limited in practice through limits in implementation and perhaps in capacity. So as a concept, human rights due diligence is powerful and appealing, and it's also new and shiny. But there are, of course, many challenges with implementing human rights due diligence, and I want to talk just two of these. The first challenge, of course, and the basic one, is getting businesses to recognise they have a responsibility to respect human rights and to undertake human rights due diligence. I think increasingly companies, multinational enterprises from Europe, North America, Australia, are at least formally expressing their commitment to engage in human rights due diligence and having nice policies on these. And for those companies that are operating out of Europe, mandatory human rights due diligence is also obviously going to help. But of course, we have to remember that take-up of human rights due diligence is limited and patchy. And it's particularly limited and patchy in our region, the Asia Pacific. And this is, of course, particularly relevant to this forum because those countries that dominate resource extraction and that dominate investment in the Pacific are from within our own region. So in this context, we need to be thinking about all the levers that we can use to promote the uptake of meaningful human rights due diligence. This includes law and other forms of regulation. But I think in our region, maybe this is my opinion, we're not going to see a lot of mandatory human rights due diligence in the short term. So we'll need to continue to creatively draw upon national and international, state and non-state based mechanisms, on multi-stakeholder initiatives, and on leveraging the influence that can be brought on companies by capital providers, by shareholders, by consumers, and by employees of those companies in their home countries, if we want to drive uptake of human rights due diligence in the region. A second challenge, and one I think we're increasingly facing with respect to companies based in Australia, Europe and North America who are investing in the Pacific, is holding companies to account for the quality of their human rights due diligence. And this is the familiar challenge of trying to narrow the gap between what is said and what is done, between policy and practice. And I think my view is that there are a number of ways that companies that formally adopt human rights due diligence are kind of distancing themselves from the obligation to undertake meaningful action on workers' rights. And I want to talk about just three of these briefly. First, there's a tendency or a risk for companies to separate how they behave in industrial relations to their corporate responsibility to respect human rights. Labour law and industrial relations is seen as somehow distinct and separate from human rights obligations. But of course, we know this isn't true, and that many labour laws and non-discrimination laws are directly bear upon and indeed afford kind of the strongest protection against human rights violations. And the companies that breach these laws are failing to meet their corporate responsibility to respect human rights. Perhaps even more importantly, I think, the UN Guiding Principles convey an expectation that companies will use their influence and leverage positively, and certainly not to undermine respect for human rights. And this extends, for example, and it's often overlooked, I think, to the business community supporting and certainly not lobbying against laws that strengthen labour law protections and human rights protections. And under the third pillar, businesses should also participate in remediation mechanisms. In an everyday practice, this may translate simply as a business participating in a conciliation conference over a labour law issue, or sitting at the bargaining table and engaging in collective bargaining with trade unions. These are all relevant. Second, I suggest that there's a kind of a risk or a tendency for companies to pick and choose which rights they focus on in their human rights due diligence. And there's a tendency for companies to adopt priorities that are easier to address, or that are most important to the business, or even that are most important to consumers of the products that they are selling back in their home countries. But this is not necessarily, this prioritization is often not consistent with the UN Guiding Principles, and it's also often inconsistent with what those working in their transnational supply chains would say are the most pressing rights to address. Concerningly, we're seeing, I think, companies adopt less of a focus on enabling labour rights, including freedom of association and the right to collective bargaining. This is despite the fact that union rights are, of course, a key issue in many countries, including in some countries in the Pacific. And that these rights are critical enabling rights, in that recognition of these rights can often lead to fulfilment of other labour rights, such as safe workplaces, reasonable working hours, adequate wages, and so on. A third way I think companies may distance themselves from a robust and meaningful human rights due diligence is around consultation and participation. The UN Guiding Principles and other corporate accountability instruments, like the ILO Tripartite Declaration or the OECD Guidelines for Multinational Enterprises, emphasise the importance of businesses consulting with rights holders and with other stakeholders throughout the human rights due diligence process. And this consultation should exist with with respect to all 4 stages of human rights due diligence. Consultation and participation is, of course, critical to ensuring that the voices of those outside the company that are impacted by its activities are heard. And this reflects kind of the basic principle as well of social dialogue, which I believe Colin will talk about a bit more in a moment. So if we just take the first step of human rights due diligence, for example, the identification and assessment of risk and of potential and actual human rights impacts in a company's operations and supply chains. A mining, timber, or tourism company that has operations in the Pacific cannot be engaging in this stage of the human rights due diligence process just from a desk in Paris or in Melbourne, or even just from a desk in Suva. Nor can they be simply engaging a law firm or a consultancy firm to do this work for them. They need to be engaging with those on the ground, including those who are actually impacted by its activities. And this includes workers, trade unions, and civil society organisations. From a labour perspective, I'd suggest that a human rights due diligence process where a company fails to engage meaningfully with those that work in its supply chain, and one that the company kind of retains complete control over what it's going to be held accountable for, how it's going to manage its risks, and how it's going to remediate those risks, where it retains complete control over these processes, I think is not a legitimate or credible one. And I think we need to be vigilant to ensure that this type of human rights due diligence does not become prevalent. I'll stop there, but I hope that my comments are useful in thinking about some of the ways that human rights due diligence can be promoted and leveraged in a way that can have a meaningful impact in the lives of workers, including the Pacific.
Thank you, Ingrid. Yeah, I think you touched on a lot of points, and I think they're very relevant for the day-to-day work. I think I find myself and my colleagues doing in our work, looking at soft labour laws in Pacific countries, so companies navigating there and taking advantage of this. And then, when there has been a human rights violation taking place, where do the people go for the third pillar of the UNGPs for an access to remedy? So, we often, try to advise NGOs we work with, or with different partners who come to us with these kind of violations, and say that, if it was a country that's a part of the OECD, then they could go to the national contact points, or we could use these international mechanisms you mentioned, such as the special rapporteurs, and get them to issue allegation letters and urgent actions, and these kind of tools they have in their box. But again, I think the larger point you mentioned, which is really interesting, is it's because the national laws often are very soft that, there's not this kind of redress, I think, that comes into it. And I think that kind of brings us into our next next speaker, Colin Fenwick, who's an expert on decent work and international labour standards. And Colin's going to discuss a little bit about the social dialogue that takes place, and also some of the international labour standards and some of the international labour inspections that can take place as well. So, Colin, over to you, please.
Well, good morning, everybody. In my case, although all 3 speakers, apart from Robert, have been Australian so far, I'm not coming to you from Melbourne, although that's where I'm from. I'm coming to you from my home in France. So good morning in every sense. It's just after midnight here. Look, thank you very much for the opportunity to participate in this, and thank you, Robert, and others for the recent reorganisation of the panel. This is fitting together very well. I just wanted to start by talking a little bit about the context. So Matthew's talked a bit about, what is the situation for modern slavery now? Modern slavery is a form of human rights violation which may take place in the context of supply chains, and therefore human rights due diligence is important. Now, the things don't always come together. So I'll talk in a little moment about which things come together and when. So a lot of what Matthew was talking about does actually touch on supply chains, because he mentioned the areas in which it's common for modern slavery, forms of forced labour and so on to take place. Fishing, agriculture, logging, Ingrid mentioned mining, So these are areas in which it's very common for the work to be done in the context of a supply chain, which brings us to this sort of nexus between a human rights and or labour law violation and state responsibility and responsibility of corporate actors, whether they be the immediate corporate actors or other corporate actors in the context of a broader supply chain. So another important point that I think from my point of view comes out, which Robert, you just touched on, in, sort of highlighting some of the things that Ingrid had said, and Matthew pointed out as well, was that, in that modern slavery report, there's talk about a lack of complaint mechanisms and weaknesses in criminal justice systems. So what that tells us is that the legal environment is really important. And this is the thing that I want to talk about in a few minutes is, why is the legal environment important? What does it do? And who's got responsibility to build and enforce that legal, make sure that that legal environment works effectively, right? So the type of laws that Matthew talked about and Ingrid's mentioned and Robert mentioned as well. So modern slavery laws and so on. These are examples, although modern slavery laws are the sort of first model of human rights due diligence laws. They're nowhere near as advanced as the UNGPs or as the French law and the European law and so on and so forth. But they are attempts to ensure that corporations, take responsibility for what happens in their offshore operations. So the next thing I wanted to talk to you about just briefly is to sort of give a picture of where the ILO sits in these things. And I'll talk a bit more about what the ILO is and what we do in a moment. Suffice to say that human rights due diligence, or more generally the issue of how the ILO can work in the space of global supply chains, has been very contentious in the office. There was a so-called general discussion at the conference in 2016. And in the resolution adopted at the end of that discussion, the tripartite constituents included what I think is a very important paragraph, paragraph 6, one of my favourites, which says governments may have limited capacity and resources to effectively monitor and enforce compliance with laws and regulations. This is the point we've just been making, right? Then it says the expansion of global supply chains across borders has exacerbated these governance gaps. So again, we've got this kind of nexus, right? We've got a combination of weak governance, whether it be in labour law or human rights more broadly or environmental protection, any of the things about which we're concerned. And you've got that being the environment in which the supply chain operation takes place. So, it's a very simple Venn diagram, right? Or Venn diagram, right? So how does this come together? Well, it all comes together in the things that I guess all of us have been saying really about institutional weaknesses. Now, when you've got institutional weaknesses, how then does due diligence fit in with that, right? How do these things come together? So the resolution from the 2016 discussion in the ILO conference also recognised this interaction, and that previous paragraph talked about weak governance and the exacerbation of the adverse impacts of weak governance from supply chain operations. Only a few paragraphs later, the constituents adopted a paragraph which says, business has a responsibility to respect labour rights in their operations as laid out in the UN Guiding Principles. And governments have the duty to implement and enforce national laws and regulations. Efforts of other stakeholders to promote workplace compliance can support, but do not replace the effectiveness and efficiency of public governance systems. And this is pretty common in sort of ILO instruments and ILO debate. This is a continuing insistence on the significance of the governance systems that should be there and of which Ingrid has spoken in the context of labour law and so on. Now, I wanted to say something about how this connects to the UN Guiding Principles, because in looking at these the other day to sort of think about what we were going to say in this panel, if you look at them, what you realise, as I did, is that an awful lot of the paragraphs in those UN Guiding Principles are actually directed to governments. They're not directed to business. 2 of the 3 pillars are directed at governments, the duty to protect and the duty to provide access to remedy. Although, as Ingrid has said, the state of governance and legal systems isn't relevant to the obligations of business. So, it's not an excuse to say there's weak governance in country X. You've still got to do the best that you can do, but we've got to work out how these things are going to come together. And another important point in this respect, why is it important to reinforce governance systems, apart from the fact that there is that obligation on governments to establish an enabling environment for business and to ensure that there is properly functioning systems of access to justice. But why is that all the more important in this context? Because the UNGPs are voluntary, and as Ingrid has said, the uptake of human rights due diligence by companies has been patchy. So what is it the ILO can do and does do in this field? Because I'm not really sure who the audience is here today. I don't know with whom I'm speaking. Some people know a lot about the ILO, Ingrid does, but I don't know whether you all do. So it's important to remember that a couple of things about the ILO. The first is that it's a tripartite organisation, right? So civil society representatives, in this case employers and workers, are embedded in both the governance structure of the organisation and in the program delivery by the office. So we are always in consultation with the constituents. And the ILO has always worked to help states to improve their governance systems in the field of labour markets, which we can identify as labour dispute resolution systems and labour inspection systems, which sort of comes to the point that Ingrid made about the overlap between labour laws and human rights laws. So these institutions, which should exist, we hope, in any functioning labour market system, are not only essential to the functioning of the labour market, but they're essential for establishing state expectations of business on human rights in the field of labour, right? So, we have a sort of advantage, the ILO, in a sense, because the ILO is a normative institution. It's one of the few international organisations which is specifically set up, at least in part, to develop international standards. Our constitution has procedures in it for that, which is not true of the Charter of the United Nations, for example. Now, whilst we are a normative institution, we haven't got very much on supply chains. We do have a tripartite declaration on social principles in multinational enterprises, which was updated subsequent to the adoption of the United Nations Guiding Principles. And it's one of the few things that really speaks to this issue. On the other hand, ILO instruments are traditional instruments of international law. They apply to member states. And in this case, they apply to work and the conditions of work. And they don't apply or not apply because a worker or an employer is or is not involved in the supply chain. They apply to work. And so this is another layer in which, the state responsibility, which is presented as in a certain way in the United Nations Guiding Principles, is really, really critical, right? Without it, we cannot make progress. As I said, Ingrid pointed out that business has its own responsibility in this respect, regardless of the state governance system, but we have to focus on the state governance system. Now, when it comes to the modern slavery aspect in particular, the ILO has got a number of instruments that relate to it directly. And one of the earlier ILO instruments, one of the first to be universally ratified, was Convention 29 on forced labour. In more recent years, the conference adopted a protocol to that concerning human trafficking. So what do we do in practice? Well, in practice, we work directly with our constituents to try and improve the governance systems, which are about respecting labour rights, which is important for business too, because business doesn't like unfair competition through failure to respect obligations in the legal system, and nor should it, and nor should the broader economy and society favour that, because a level playing field is what is required for fair competition and for better growth and to drive productivity improvement and all those good things, right? So the advantage of the ILO in the way that we engage with the constituents and the way in which we encourage the constituents to engage in each other is that we are in constant contact with the users of the system. Employers and workers are the users of the system, which is to say the employers are those who have obligations to respect human rights in the field of labour, and workers are the ones who should benefit from the enjoyment of those rights. And there are then two kinds of institutions, I suppose, which are relevant, of which I spoke. There's labour inspectorates, which are at the forefront of law enforcement. Now, in the language of the UNGPs, of ensuring the state fulfills its obligations to establish expectations of business and to ensure access to remedy. Now, labour inspectorates are notoriously under-resourced across the world. I don't yet know the Pacific because I haven't yet, although I'm in my job, I haven't yet got to the Pacific, but I will on Sunday, so watch out. What the ILO has done in recent years is to develop a methodology for enabling poorer labour inspectorates basically to maximise their resources through a process called strategic compliance planning. So we work with labour, well, I don't, but my colleagues in this field do. They work with labour inspectorates to, identify where are the key issues and to figure out how to have the biggest impact in terms of law enforcement, how to send the biggest signal to business across an industry or in a sector or in an area of, in a geographic area, as the case may be. And then we also work with labour dispute resolution institutions. Now, in this field, there are state institutions, whether courts, judicial institutions, or tribunals, non-judicial institutions. And we work with non-state institutions of labour dispute resolution. So what happens at the workplace? And if you think about this from the point of view of industrial relations, and I'm very interested by Ingrid's observation that companies tend to think of their human rights work and their industrial relations work as different spheres because, labour rights are human rights. It's really just that simple. But grievance procedures at the level of the workplace cooperations mechanisms, and collective bargaining systems are critical, right? So this brings me to another of the points that Ingrid made about how critical it is to have access, to have freedom of association. Now, freedom of association is literally a constitutional principle, a foundational principle of the ILO. And it's a freedom to establish representative organisations, to engage in collective bargaining. Now, this is really the thing which I think sets apart the ILO and its instruments and the world of labour law from other aspects of human rights more broadly written, because there is a constant engagement through this process of social dialogue, which is an expression that Ingrid also used. But what's really interesting about social dialogue is that whether it's through collective bargaining or whether it's the state engaging with workers and employers or the ILO encouraging them to do so, is that to a greater or lesser extent, this happens all of the time. And the challenge that this could help to overcome in terms of the implementation of the UN guiding principles is the issue of stakeholder consultation, which if you look at the literature around the UNGPs, if you look at the literature around corporate social responsibility initiatives, in addition to the problem of voluntary uptake, you've got a problem of inability or unwillingness or lack of knowledge of how to engage with stakeholders. Now, over in the world of labour law and in the world of the ILO, stakeholder consultation is of the essence. It's just we happen to call it social dialogue. So those are a few brief reflections on sort of the ILO's place in this, and also trying to link these worlds of labour and human rights and UN guiding principles. And so thanks for your attention, and if you've got any questions, then I'm sure I'll be happy to answer them.
Thank you very much, Colin. It's really interesting to highlight all the specific work I think ILO has been working on, how these kind of different aspects of ILO's work, particularly in the normative framework, a bit like OHCHR, can be brought into these kind of different aspects of human rights and the business and principles. We've had a number of questions from the chat, so I want to sort of have a look and see if we can have a delve into them. Many relating to mining companies and extractive industries in the Pacific. One I think which is quite interesting that's come in is, how do Indigenous people with weak judiciaries in their countries participate in international legal mechanisms for justice on human rights violations? And I thought maybe, Ingrid, we could come to you first on that one, and then maybe circle back to Colin, in particular in relation to ILO Convention 169, which I think is quite relevant here. So Ingrid, over to you, please.
Look, I think there's 3 questions in the chat from the same person, from James, and I wanted to very briefly. There's been a lot of talk about the grievance, and there was yesterday about the grievance mechanism at the Porgera mine in PNG, and I think I agree, and I actually teach this as a case study in my graduate business and human rights class, because it's such a good example of what I was talking about, where, you know, companies have their due diligence, you know, they kind of say they have their human rights due diligence in place, they kind of position themselves as leaders in human rights due diligence, but they're never actually giving up any control to shape what that human rights due diligence looks like. And same with the remediation mechanism, never giving up, you know, any control about what that addresses, when it addresses, you know, who is eligible. And so I think, you know, rightly, there should be a lot of concern around those, you know, human rights due diligence carried out in that way. And I think that's really, I guess that's the point that I was trying to underscore, that, you know, that human rights due diligence per se, I don't think is a good thing or a bad thing. I don't think it's a sword or a shield. I think it's, you know, it's what is the quality of that human rights due diligence, and is it, you know, is it being undertaken in a way that is legitimate and inclusive and credible, and that businesses are held accountable for. And I think that's really a really important, I guess, example that the questions have raised about barrack mining operations. My area, look, I mean, to be honest, my area of expertise is not rights of Indigenous people, so I don't want to, I'll leave that to Colin. I guess more broadly, in terms of using international legal mechanisms for workers' rights, labour rights violations, there are, of course, many, I guess. They don't, probably still not adequate, but there is certainly, obviously, many avenues at the transnational level that include ILO complaints mechanisms, where it concerns kind of state involvement. There is, Robert, you mentioned the OECD guidelines for multinational enterprises, which have a complaints mechanism, which is increasingly, I think, important. And we've seen, for example, in Australia, some kind of our national contact point become stronger, kind of be improved significantly. And we saw, I don't know if anyone's familiar with the kind of the case of ANZ financing a company in Cambodia that engaged in child labour and other kind of forms of human rights violations, land grabs and so on. And that through the OECD national contact point mechanism in Australia actually had really positive results and led to ANZ using the profits from that bank loan to actually remediate some of the impacts that their investment had caused. And I think that's a really good example as well, because it involves a whole, I guess, a transnational network. You had, I think it's Inclusive Development Cambodia, which was the NGO within Cambodia. You used NGOs like Banktrack to follow the money for who was actually financing the company. You know, that led to ANZ. You then had NGOs in Australia who are also helping, kind of willing to work with the NGOs in Cambodia. So it's, I guess, these examples of how basically international, transnational networks, for good or bad, are, I think, the way that these international mechanisms can most successfully be leveraged. I'll leave it to Colin to continue answering that question.
Thanks, Ingrid. Colin, straight over to you, I think, and then maybe a couple of comments, and I'll go to a few more questions.
Okay, well, I mean, I'm an ILO specialist, but neither am I an expert on Convention 169 or Indigenous and Tribal Peoples, although, as luck would have it, a few weeks ago, I had to refresh my memory on it. The first thing I'd say about it is that Fiji is the only country in the region that's ratified it. It's not a very widely ratified instrument. And so, there are very few mechanisms in the ILO supervisory system that are available when a state hasn't ratified a convention. So first things first is to get nations in the region to ratify, which hasn't happened. Now, I haven't yet got there, so I don't know to what extent it's even under consideration. But Convention 169 is an interesting instrument because it well and truly predates what the UN has been able to do in this space. Again, in part because of the fact that the ILO Constitution sets up a mechanism by which to adopt conventions. It's also an interesting instrument because it has echoes of or connections to the instruments on forced labour, because the first of those, the Forced Labour Convention from 1932, number 29, is really about regulating the conditions of labour of colonised populations. That's what it's actually about. And what's really interesting about Convention 169 is it takes a very revolutionary approach to the way in which Indigenous peoples should be conceived of, or better put, how they should be able to participate in processes that affect their rights. And so if you look at the Declaration on the Rights of Indigenous Peoples, you'll see reference to the concept of free, prior and informed consent. Now, this was in a sense, if not pioneered by, at least prefigured by ILO Convention 169, because it's all about the idea that Indigenous people should be integrally involved in discussions and decisions about processes and developments like mines, which affect their territory. And a lot of the cases that have come through, a lot of they're called representations under Article 24 of the ILO Constitution. A lot of those have been about development in rural and regional areas, particularly in Latin America. There's a lot of Latin American countries have ratified that convention. Of course, a lot of them have Indigenous populations. But the essence of it is, true recognition of the cultural heritage and nature and the rights of Indigenous populations, and that manifesting itself in proper processes for consultation in which both Indigenous people have the ability and the right to determine their own representatives and participate, and in which the state has an obligation to respect those representative institutions and to facilitate their development as well, right? So, Convention 169 is in many respects endlessly fascinating because it goes well beyond the world of just labour. It goes into territory, it goes into cultural history and all sorts of things. But absent ratification of the instrument, there's not a lot that can be done. Interestingly, Fiji is the only country in the region that has ratified. And that's not interesting necessarily. What's interesting is that Fiji is an unusual country in which, from the point of view of the traditional approach to protection of Indigenous rights, because the Indigenous population are the majority, not the minority. But obviously that's not the case in other parts of the Pacific. And so, mining takes place in the Solomons, it takes place in Papua New Guinea, other places as well. And a lot of those populations are not being consulted at all. Now, how much that would change had those countries ratified Convention 169? Open question, but at least it provides, like all international instruments, it at least provides a framework in which to start an engagement and a dialogue.
Thank you, Colin. That's a good point, and I think that relates quite well to what Ingrid said about human rights due diligence. You can have these things in place, but if the political will isn't there to actually implement them, then it's just another thing that maybe some company might use to tick a box. There's been an interesting question posed on freedom of expression, which I think all the panelists have kind of touched upon. And this I want to hand over to Matthew. The question was, how do we deal with a situation where there's no independent trade unions, and what should companies do in terms of how they engage with this situation?
Sure, I'm happy to have a crack at answering that. Obviously, following the logic of UN guiding principles, corporate responsibility to respect, companies need to put in place policy, human rights due diligence, and a remediation mechanism. As Ingrid has mentioned, consultation with stakeholders is very important through all of those different structural approaches. And so in the absence of independent trade unions, I think businesses should be looking more broadly at the types of stakeholders that they can engage with. The human rights due diligence process can be framed broadly. We've spoken about stakeholder consultation, but businesses can rely on other resources to find out information. I guess, which is one of the main themes that's coming through murky waters, that there hasn't been enough research done on modern slavery itself in the Pacific, and we need to do more. One of my observations working with companies is that often their knowledge of their supply chains is quite weak, and the available information is fairly scarce, the more complex the supply chain is. So I think in the case of extractive companies, they might tend to know their businesses quite well, but other businesses and other sectors may not. So the more information that we can generate and provide, the easier it is for companies to conduct effective risk assessments and to follow that up with proper due diligence processes. And to touch on a point that Ingrid made before, to be able to identify their full range of material risks in the language of companies, or salient risks in the language of the UNGPs. And then I guess the use of remediation mechanisms is also important where there's a lack of freedom of speech, and UNGPs obviously provides criteria for what good remediation mechanisms look like, and in particular operational level mechanisms. I think more work needs to be done on how companies set up and run those mechanisms, and what type of procedures they're setting up, how people can access them, are they making rights-based decisions, how much transparency is in the process. And I guess the use of those mechanisms is another way to get around lack of freedom of speech, obviously bearing in mind that companies need to provide non-retaliation guarantees for using those mechanisms. So off the top of my head, that's my answer to that question.
Thank you very much, Matthew. Yeah, I think all these kind of aspects are really the crux of actually doing business in a country, when you realise that that maybe there isn't independent trade unions, or trade unions aren't allowed to flourish freely or speak freely, and how do companies engage? It's often a question that many of the companies find when they go into a different country, and these kind of problems that arise. There's actually been a comment and a question raised from our Fiji hub, so I'm going to go over to our Fiji hub for this comment. Over to you. Thank you. Please go ahead.
I didn't thank you for your presentations. Maybe we have missed it, but did anyone mention?
Sorry, can you speak up a little? It's difficult to hear.
Thank you for your presentations. We might have missed it on this side, but would anyone have mentioned or shared anything in regards to cases around Indigenous, Aboriginal, and Torres Strait Islanders in relation to human rights violations and companies? That's one. And the other second one was just in relation to the comment and question before us about trade unions. I think that's something we'd like to know a little bit more here in Fiji, given our limitations about exercising freedom of speech and rights to do with trade unions and meeting and protesting, etc. Thank you.
Thank you. So, sorry, the volume was a little bit low, but I think I got the majority of the question. I think, Ingrid, there was a question again on the trade unions and how to, promote the freedom of expression and what companies can do. Maybe I can pass to you for some advice that you'd like to share there.
Yeah, look, I think I actually worked on, I used to, when I worked for the Australian Council of Trade Unions, I worked in Geneva on the Fiji case before the ILO concerning limits on freedom of association in Fiji. And so I think it's important to recognise that there are ILO mechanisms which can be used to pursue, to raise concerns internationally about restrictions imposed by law on freedom of association, and the Fiji trade unions have used these, and so I guess that's good in a way. Unfortunately, it's one thing to get the ILO to observe that the laws are non-compliant with international standards, and it's another to actually change the conditions on the ground. But I do think that those international mechanisms are definitely worth pursuing and continuing to pursue. I think the question around business responsibilities, it's difficult. And I think, like Robert and Matthew both mentioned, it's difficult, and it's, I think that, it's often, first and foremost, I think it's businesses not supporting the imposition of restrictions on trade union rights. I think I've mentioned this before. I think this is often overlooked. Whether it's businesses not supporting laws, even kind of opposing, voicing their concern about laws or decrees that limit rights to association and trade union rights. And I think that's really important. On a practical level, I think that, the issue for business is how to, uphold international standards to the extent possible. And this will include, I guess, trying to think about how they, workers' voice and recognise independent workers' representation within the frameworks that exist. I think it's really important that they don't try and create their own kind of trade unions that may be employer kind of dominated or managed, and that's obviously not a good solution at all, but that happens. I'm not sure if that answers the question. I think, in any of these cases, I do think, and maybe this is because it's an area that I worked in, but I do think the international trade union movement, kind of countries like Fiji or something, leveraging and using I guess activists using international trade union movement, whether it's the global unions or the International Trade Union Confederation or other international human rights organisations, to continue to raise concerns and draw awareness, I guess, around the world to continuing restrictions in countries is really important as well.
Thank you, Ingrid. I think it's a good point about the international mechanisms. I mean, just speaking on my own personal experience as well, often, the trade unions, it's a particular issue that, at a certain time that they're actually, want to protest about or want to discuss. So it might be something like labor rights in a certain factory, or access to water that, their union members are taking forward. And therefore, I think, these different mechanisms like the special rapporteurs, can actually write, directly to the special rapporteurs, and they can issue letters about these, which I think is a good way to actually sort of take forward sometimes issue-based things rather than addressing the whole system that's kind of pushing them down from actually talking. There's one last question I'd like to pose, and I think I'll come to Colin first because that's actually related to ILO, but then maybe I'll throw it out to both our panelists. What support can ILO provide to migrant workers or seasonal workers, which is quite specific for our region, who are often trapped in exploitative situations? Colin?
Well, yeah, that's complicated. I mean, migration is necessarily complicated. Well, migration makes it complicated to address issues because it necessarily involves more than one jurisdiction, right? So we do have ILO instruments about migration, and one of the ILO instruments on migration, I think it's 107, I can't remember now, does specifically enjoin countries to cooperate with each other. So, you know, sending countries and receiving countries are supposed to help. The way in which the ILO has worked on this well, okay, there are always projects run around in different countries around the world around assisting workers to understand their rights, providing better facilities for migrant workers, providing organisations that can help them, and so on. Interestingly, some of that work was done in Qatar in recent years, and that also involved addressing the institutions, the labour inspectorate, and so on. One of the things I think one of the most important developments in recent years has been the adoption of what we call the Fair Recruitment Guidelines. So they go beyond our convention on private employment agencies, and they sort of meld that with the migration stuff. And there's a lot of detailed guidance in there about what states can and should do in terms of regulating labour agencies which are engaged in the business of, you know, facilitating migration for work. Certainly, we've got standards there which apply both to private employment agencies and to the countries themselves about what is or isn't legitimate and fair in terms of exploitation of migrant workers. What the ILO can't do is address the case of any individual migrant worker or group of migrant workers. The ILO doesn't have that power any more than the UN does. So, you know, we have to work through our existing constituents, and we have to work where governments enable us to do so because they're the member states.
Thanks, Colin. Yeah, I think it just draws us well to the end of the session, actually. And I think, you know, we've covered a lot of information here. You know, there's a lot of discussion taking place, particularly on the laws and what needs to be changed. But I think it's been a good session in relation to, you know, what remedies are available and the kind of discussion around this that people who are participating can look at and say, okay, I can go back and research a bit more on that. So I'd just like to thank all the participants who've taken part, Ingrid, Matthew and Colin. It's been really useful for me to sort of, like, you know, pick up some points that I didn't know about particularly. And we'll see everybody back for 12 o'clock at Fiji time. So thank you very much.
Thank you.
Thank you.